Welcome, viewers. I'm Dr. JW, theologist. Like, subscribe to help me, comment to educate me, and share to help somebody else. Before I play this clip, watch the institutional pressure in the room. This is not merely a debate about language. It is a confrontation over whether Australian law can still clearly recognise and protect women as women. The Sex Discrimination Commissioner is being asked a basic legal question. If the law cannot clearly affirm male and female as stable, recognisable sex categories, how can it faithfully protect female privacy, dignity, safety, sport, shelters, prisons, recovery spaces, and sex-based rights? The 2013 amendments under the Gillard government to the Sex Discrimination Act introduced gender identity protections, but the unresolved problem is now exposed. When gender identity is elevated without firm sex-based restraint, female-only protections become legally unstable. And that instability is not theoretical. It creates real-life threatening risk. Women may be left carrying the consequences of institutional ambiguity, while the very office responsible for sex discrimination appears unable to clearly explain how women remain protected as a biological sex class. And this is the deeper issue, viewers. Human institutions are not sovereign over male and female reality. When law defines divine sovereign restraint, they've defied it. The law has defined divine sovereign restraint. It stops recognizing created distinction and begins treating reality as administratively negotiable. So watch carefully. The question's no longer only what is a woman. The question is, and I challenge you as you watch this, viewers, can a legal system protect women after it has made the meaning of women completely and utterly uncertain?
Senator Cash.
Thank you very much, Chair. Commissioner Cody, if we continue with our analysis post the Tickle and Giggle decision, just in terms of, you were speaking prior to the break of special measures, so a special measure intended to achieve gender equality. That's not applied for, is it? You don't need to, do you have to apply for a special measure?
No.
No. You just argue it is a special measure.
Correct.
If you're actually challenged.
Correct.
So a person may take a special measure for the purposes of achieving substantive equality between men and women, or people who have different sexual orientations, or people who have different gender identities. So just on the basis of the Jackie Turner International Women's Day for and by trans women only event, which one would they fit into if they were arguing we said no to a biological woman and it's a special measure? How do they fit into that?
So I'd correct my previous answer, Senator, in that event, I've now learnt, was open to all women and also to all men, and both men and women went to that event.
If, though it was just to work through the legal position, if they wanted a trans women only event, and you said that would be a special measure, can I just ask, how do you fit into one of the three, obviously not men and women, how do you actually legally fit into it?
So it may be it is for the purpose of achieving substantive equality.
Yes.
So that issue would be depending on which group of trans women, for example, what the nature of the event is, how long it was for, and what the purpose of it was.
And that only comes up in the event that it's challenged?
Correct.
And then they would argue it is a special measure?
That's correct.
Understood, right. Can I just go, though, the Lesbian Action Group, in saying no to transgender women, they can't argue it's a special measure?
They could argue that it's a special measure, but they had sought an exemption, so the court case was around their exemption.
The exemption. How would they argue it's a special measure that biological women want to exclude trans women who are biological men? How do you fit legally within that?
They would have to demonstrate that it was to achieve the substantive equality between lesbians and... I'd have to look at it, Senator. I'd find it difficult to do that mental...
no, that's okay. I was just trying to get an idea of how the special measures actually work to understand the law as it stands. So I'll continue on. So gender identity is a protected attribute under the Sex Discrimination Act. Is biological sex a protected attribute?
Sex is an inclusive term.
No,
it draws...
biological. No, I'm asking you, is biological sex a protected attribute?
So to answer your question, sex is an inclusive term. It includes all women. That includes what you're referring to as biological women. It includes First Nations women, women with disability, trans women, and those who are intersex also, who may identify as women.
Prior to 2013, what was the meaning of biological sex or man and women in the Act?
There was a definition of woman in the Act. I couldn't give you the
And it was a
words of it.
biological definition?
I don't remember the terms of it, Senator Cash.
We took out the definition of man and women in biology in 2013. So that's currently what's missing from the Act. Is that correct, that standalone definition of man and woman?
No, Senator. The current term, the Sex Discrimination Act has multiple objects,
yes,
and it reflects a range of human rights obligations that Australia has under the civil and political rights, economic, social, cultural rights, as well as CEDAW. And CEDAW has been interpreted to have an inclusive definition of women, and it includes trans women, and that is why the Act is now inclusive of our human rights obligations under that range of instruments.
So how would you ensure that biological sex as a stand-alone is a protected attribute? Stand-alone, only confined to biological sex. Would you have to amend the Sex Discrimination Act?
That would be up to Parliament to decide.
I'm just asking from the legal position.
I can't give you an opinion on that because that would be counter to our obligations under human rights law.
I don't know how answering a question about whether or not changing an act is contrary to your obligations at human rights law. Seriously.
Because women is defined in an inclusive way under the Convention for the Elimination of Discrimination Against Women.
That's the problem at the moment. That's what we're saying. The law is actually currently the problem. So we're saying if you included back a definition of biological sex as a standalone, is that how you can actually get it to be the protected attribute?
I think the Commissioner's answered your question, Senator Cash.
So can I go to some real-world consequences now of the tickle and giggle just to understand it from a legal perspective? Because I want to understand exactly how the law flowing from this decision now applies. So your Commission's, I think it's the Trans Explainer, states that excluding a trans woman from services or spaces for women would likely be considered discrimination. Is that correct?
On the basis of gender identity.
Yes. So under that guidance, can a women's refuge turn away a biological male who identifies as a woman on the legal basis?
It depends on the grounds on which they are excluding I think what you're referring to is a trans woman, what I would refer to as a trans woman, whether a refuge can exclude
a biological male who identifies as a woman, yes.
It would have to be generally what the practice is in those situations is that they will make a decision on the basis of who's currently in the refuge, what their concerns are, and the particular safety needs of both those who are within the refuge as well as the safety needs of the person who's seeking refuge.
But you've said it would be likely to be considered discrimination.
I don't think that's what I answered, Senator.
So I'm saying, can a women's refuge turn away a biological male who identifies as a woman?
It would depend. It would be a case-by-case decision. If the refuge is for example, women who've experienced domestic or family violence from men, then it may be a legitimate decision to turn away a trans woman. It would depend on the circumstances and the needs of the individuals who are actually in the refuge at the time.
If they turned away the biological man who identifies as a woman, a claim can still be brought, correct? For discrimination?
I'm sorry, Senator, you're going to have to be a bit more specific. A claim by who?
The person who was turned away, that they were discriminated against, according to your Trans Explainer.
She may be able to make a complaint,
yes.
and depending on the circumstances as to whether or not there would be a finding of discrimination.
What do the service then argue?
It would be up to the service to make its argument as to why they had made that decision and the needs of the other participants or the other people who were staying in the refuge at the time.
And so where does that legally fit in the Act?
Well, if someone made a complaint, then that would be their response to the complaint.
But what's the legal basis for it? I have to have a legal defence. What's my defence under the Act?
That it's not unlawful discrimination because it's for the purpose of it's a special measure, so it's for the purpose of achieving substantive equality of women.
Okay. Could I just turn to another issue? Did you send an email to the AHRC Chief Executive Leanne Smith asking whether GANRI could have any role in influencing the reappointment of UN Special Rapporteur Reem Al-Salem?
Senator, I did send an email seeking advice about the appointment processes for special measures.
Right. What was the date of the email?
I'd have to take that on notice, Senator.
Can you also table a copy of that email with the Senate committee?
Yes, Senator.
Thank you. My understanding is Ms Al-Salam sought to intervene in Tickle and Giggle to argue that women means biological female. Is that correct?
I would have to refresh my memory on the grounds or the submissions or the grounds on which the Special Rapporteur sought to intervene.
Can I just confirm, is your evidence, did you in any way seek to influence the reappointment of the UN Special Rapporteur?
No, Senator, I did not.
Okay, and that is your evidence?
That is my evidence.
Okay. And you are aware of UN Human Rights Council Resolution 5.2, which provides that mandate holders must carry out their functions free from undue influence or intimidation?
Yes, Senator, I am now.
Excellent, good. President, were you aware of the email that the Sex Discrimination Commissioner sent?
Not before it was sent.
Have you seen it?
I don't believe so.
No,
But it came up in the last round of estimates. There was
Yes,
questions
yes.
about it.
So you weren't aware of it before then, though?
No.
Okay. And you will take it on notice to provide a copy of that to the committee?
Yes, Senator.
Thank you very much. Did you?
That exchange should concern every Australian who believes law must protect reality and not dissolve it. The Sex Discrimination Commissioner appeared unable to provide the clarity required to defend women as a sex-based class. And that's not a minor administrative weakness, viewers. It is an institutional exposure. The 2013 Gillard Framework may have been presented as inclusion, but inclusion without firm sex-based boundaries risks becoming partially against women. And if male and female are not legally stable, then women's protections are not legally stable either. And this is where the danger sharpens. The issue is not hostility toward anyone. The issue is whether legal ambiguity can be exploited in ways that expose women to risk in places especially designed for male privacy, dignity, safety, and recovery. And when a chair appears to contain the questioning, and the Commissioner cannot clearly answer the biological foundation of women's protection, the public sees the contradiction. The law claims to defend women while struggling to define the class it is defending. And that is defiance of the Constitution's defined sovereign restraint. Male and female reality is not administrative invention. It is a created distinction human authority was not meant to recognise and protect. Now, my final question. If the office responsible for sex discrimination cannot clearly explain how women remain protected as women, then what is being protected, women or the legal framework that made women's protection completely, utterly, and in defiance of the Creator, uncertain?